All right, let's dive into a fascinating real-world story. It's one of those things that really pulls back the curtain on how laws are actually interpreted. It all starts with something super relatable, a parking dispute, but where it ends up teaches us a huge lesson about how our entire legal system is built.
So get this. Picture a pregnant woman. You can tell she's having a hard time getting around, and she's told she has to pay for parking. But the sign right there says that seniors and people with disabilities get a pass. Your first gut reaction is probably, wait, that's totally unfair. She clearly needs the break too. And that feeling, that simple question of fairness, that's exactly where our whole story kicks off.
See, the city ordinance itself is actually crystal clear. On one side, you've got the groups who are specifically named, the ones who get the benefit, senior citizens and persons with a disability. And on the other side, our pregnant woman. She's denied because, well, her group isn't on that list. The law has drawn a very, very specific line in the sand. Now, before we get into all the heavy legal Latin, let's just think about it like this for a second. Imagine you get a party invitation, and it says partners welcome. You just kind of know that means you can bring your spouse or your significant other, right? It doesn't mean you can show up with your cousins, your aunts, and your brother-in-law. By specifically including one group, the host has pretty clearly excluded everyone else. This simple idea, it's the key to this whole case. And believe it or not, that exact idea has a formal, fancy name in the legal world, Expressio Unius Est Exclusio Alterius. Yeah, it's a mouthful, I know, but all it really means is that when a law goes out of its way to list specific things, courts have to assume it was done for a reason. So the very act of listing senior citizens and PWDs is seen as a deliberate signal to leave everyone else out. And there's even a sister principle that kind of doubles down on this, called Casus Omissus pro Omisso Habendus Est. This one basically says if something is left out of a legal text, it wasn't an accident. The law presumes that the lawmakers, the city council in this situation, they thought about it, and if they didn't include pregnant women, it's because they intentionally chose not to. I know, it might sound a little cold, maybe too rigid, but there are some incredibly important reasons why courts stick to this rule. First, it gives us legal certainty. We all need to know exactly what the law says without having to guess. It also shows respect for the lawmakers and upholds the separation of powers. Remember, courts are supposed to interpret laws, not rewrite them. And honestly, it's just practical. A clear list is just way easier for everyone to enforce. And hey, this isn't just some abstract theory. It's actually how the system works. The Philippine Supreme Court said it perfectly in a major case. They basically said if a law's words are clear, you don't go looking for hidden meanings. You just apply it exactly as it's written. End of story. It's a bedrock rule that keeps the whole legal system from going off the rails. So this really gets to the heart of the matter, doesn't it? It's a classic battle. On one side, you've got the spirit of the law argument. It's that emotional, common sense feeling that the law's whole point is to help vulnerable people, and this woman is definitely vulnerable. But on the other side, you've got the letter of the law, which just says, nope, the text is what the text is, and that's all that matters. And this difference gets even more obvious when you look at the actual words the law uses. Senior citizen and person with disability. They aren't just general descriptions. They're what lawyers call terms of art. They have very precise official definitions. A senior citizen is someone aged 60 or over. A person with disability is someone with a long-term impairment. And this, right here, is where the woman's legal argument completely falls apart. Because while pregnancy can absolutely feel disabling in an everyday sense, from a legal standpoint, it's a temporary condition. It just doesn't fit into the legal box of a long-term physical impairment that the law spells out. The words have a very specific meaning, and her situation, unfortunately, doesn't meet that definition. And this really puts the final nail in the coffin for that spirit of the law argument. The Supreme Court was incredibly blunt in another case. They said, you simply cannot use the supposed spirit of a law to excuse ignoring its clear written words. When the two are in conflict, the letter of the law is going to win every time. So the crucial point, the big takeaway is this. A judge's job is to be a referee. They're there to apply the rules that are already in the rule book. It's not their job to grab a pen and add new rules or new players to the game. If the city council had wanted to include pregnant women, they had to write it into the law. A court just can't do it for them. So is she just out of luck then? Well, no, not at all. The legal fight might be a dead end, but that doesn't mean there aren't other options. The real path to change here isn't in a courtroom. It's political. She can lobby the city council to actually change the law.
Or on a simpler level, she could appeal directly to the mall, not based on the law, but just on plain old good customer service. The law can be rigid, sure, but people and policies can always be flexible.
And that really leaves us with the big question, doesn't it? This whole case brings up this fundamental tension that you find in any legal system. On the one hand, we want laws to be fair, to be compassionate, but on the other, we need them to be stable, predictable, and applied the same way for everyone. Trying to find that perfect balance, well, that's the never-ending challenge of making good law.